3, 2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Good morning and welcome to the Tennessee Court of Appeals. We appreciate each of you agreeing to participate in this oral argument via Zoom today. We think it's probably the safest way to go ahead and conduct court business based upon everything that's going on these days. I will remind each of you, though, that even though we're doing this via Zoom, the same rules, protocol, and procedure apply as if we were all standing in the courtroom today. Essentially, what that means for the framework of today's argument is that each side gets 15 minutes to make its oral argument. If you're the appellant and you've reserved rebuttal time with Mr. Hibner previously, then you will receive that rebuttal time. Before we start today, I need to also remind everyone that this argument is being live streamed. And in keeping with that, I want to be sure and introduce our panel for this morning. We have Judge Skip Frierson from Morristown, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case then.
Anthony T. Grose versus David Kustoff et al.
All right, and Mr. Grose, I understand you are self-represented here today. Is that correct?
Yes, Your Honor.
Okay, and what we're going to do, we're not going to start the clock yet, but I want to make sure that you understand that you have 15 minutes to make your oral argument. Apparently, you reserve 5 minutes of rebuttal time, and when we start, you can tell us anything you want to about the case. Do you have any questions, anything you don't understand before we get started?
No, Your Honor.
All right, then you may proceed, sir. Before we start, though, I need you to introduce yourself for the court because not only is this being live streamed, it's also being recorded. So we need to know who's talking. So,
sir. Thank you, Your Honor. Good morning, Your Honor. My name is Anthony Grose. I am one of 6 plaintiffs, but we have some technical difficulty here.
That's okay.
Can you hear me now?
Yeah, we
can
can hear you. We're fine.
I was stating I am one of 6 plaintiffs appellates of heirs and beneficiaries to this wrongful death lawsuit of the trial court's consolidated lawsuits of claims of attorney breach of contract, abandonment, and attorney malpractice and attorney negligence. The defendants, appellees, were contracted to represent the estate of Lucille Grose's heirs of a wrongful death lawsuit of an automobile fatality crash. The trial court dismissed plaintiff's claims on an order on defendant's motion for summary judgments on the basis that plaintiff failures to produce and bring forth an expert witness to contradict or refute the attorney's malpractice claim. In representation of the plaintiff's appellee's wrongful death lawsuit that is ongoing in litigation within the circuit trial court at Shelby County, Tennessee. This is a plaintiff appellate's pro se lawsuits that is not by choice of suing the defendant's attorneys who had represented the plaintiffs in litigations related to an April 21st, 2017 lawsuit alleging the defendants committed acts of attorney abandonment, breach of contract, attorney malpractice, and attorney negligence, for which the plaintiffs and appellees amended and supplemented their claims on October 30th, 2019, specifying specific acts as it relates to the attorney malpractice and fraud schemes. They included in that particular amended complaint a breach of contract, malpractice, errors and omissions, attorney negligence due to providing competency and skillful representation and duty to act properly and acting carelessly or by making mistakes. The attorney withdrawal and abandonment without a cause was an obstruction scheme. The attorneys defrauded and deceited fraud and or fraudulent schemes. And in a legal malpractice case, the plaintiff must usually present expert testimony regarding the standard of care in causation under certain circumstances. These lawsuits are unique and unusual, and it involves licensed attorneys and experts, which the appellates claimed and went to various attorneys seeking expert witness, but were felt they were being discriminated against and unwillingness and attorneys' unwillingness to refute their fellow colleagues for their professional duty of standard of care and proximity causation to their clients in these lawsuits. The court must analyze that the trial court grant of summary judgment on the legal malpractice claim. The trial court held that expert proof was required as to the proximity causation in this case. And the plaintiff had not satisfied this burden with an expert, which the Court of Appeals shall not affirm. Being that the plaintiffs are pro se laymen and are not expert attorneys, even though they felt that they were being blacklisted and discriminated against when they sought to find legal representation to represent them in this case. On the reasons aforementioned, as continuously cited in the record on appeal, that the pro se plaintiffs litigants did experience expert attorneys, law firms, discrimination and blacklisting, obstruction of justice that prevented plaintiffs' due diligence of obtaining an expert attorney witness within the local jurisdiction and throughout the state of Tennessee. The trial court has to proximate causation to these courts' consolidated lawsuits. As it is for this reason of discrimination and blacklisting by bar licensed local attorneys and law firms and attorneys throughout the state of Tennessee, for which the pro se's due diligence reveals that the exception to the rule of law shall apply under these adverse conditions, being that the plaintiffs were unable to find legal representation. Appellants now are aware of their experience throughout these litigation proceedings. Certain members of the society are governed by special rules in their professionalism, like lawyers, doctors, and nurses. The plaintiffs must usually present an expert witness regarding the standard of care and proximity causation comes into question in this case. In comparison to the rule of law, this court shall consider supremacy of law, equality of law, judge-made constitution. Second, summary judgment was not appropriate at the pre-trial stage to these cases. Both parties presented summary judgment motions to the court. It was clear and evident that material evidence of fact remains in dispute amongst the parties. The defendants failed to respond accordingly to any of the plaintiff's cross motion for summary judgments and the plaintiff's undisputed facts of claims. The plaintiff claim legal malpractice must prove, one, that the defendant's lawyer owed a duty to the plaintiff, that the lawyer breached the duty, three, that the plaintiff was damaged, that the lawyer conduct was the cause of the fact of the damages, and five, that the lawyer's conduct was the proximate or legal cause of the plaintiff's damages. Further, the plaintiff must show that they would have prevailed in the underlying action, but for the attorney's malpractice. It is this element that proves that the summary judgment decision by the trial court and these appellate lawsuits are premature, and the appeal court shall remand all these lawsuits back to the trial court because there is ongoing pending litigation in the wrongful death lawsuit. Regarding the need for an expert in legal malpractice cases, Tennessee case law states whether a lawyer conduct meets the applicable professional standard is generally believed to be beyond the common knowledge of the laypersons. Thus, except in cases involving clear and probable negligence, most courts consider the issue have held that cases of legal malpractice cannot be decided without an expert proof regarding the applicable standard of care and whether the lawyer's conduct complies with these standards. Further, the requirements of an expert testimony includes testimony on issues of causation. Here, because of the underlying open case involved a sophisticated case of bad faith insurance, the tampering of evidence, the state farm attorney's obstruction of justice and fraud before the trial court, the appellate court shall not affirm the holding that the expert attorney as a proximate case was an essential element to the plaintiff's claim of legal malpractice. There is also, the case was being asked to be stayed based on the pending litigation to the underlying case that is still underlying for the wrongful death, that the plaintiffs had pursued and asked the court continuously to put the case on stay and on hold until that could be resolved. The court denied those motions. The defendants in his own expert the defendant is his own expert witness. In this case, he submitted an affidavit recording the circumstances which led to the underlying lawsuits and the strategies involved in plaintiff's defense and prosecution of the cross counterclaims. Defendant's own affidavit theories to not defend plaintiffs after the plaintiffs filed their lawsuits for damages give rise of a reason to a breach of contract that violated the trial court's local rule. When the defendant came before the trial court, he did not state what his reason for the withdrawal was, which left the plaintiffs, the appellates, standing at the feet of the court to dismiss the case after the State Farm attorney came forward in motion to dismiss the case. For these reasons, the appeal court should look at this case because it is unique. It involves multiple heirs and beneficiaries to their claims of an attorney not showing the standard reason of care to assist his clients in pursuing a wrongful death case. And that's where this claim lies in. Summary judgment, there was no discovery done or no discovery motion scheduling orders set by the trial court to place the litigation into discovery prior to filing of a motion for summary judgment. The court next should look at summary judgment of the claim on the loss of inheritance and the beneficiaries to their mother's estate. The trial court based this decision on the fact that the plaintiffs failed to bring forth an expert witness, as I said, but there are still damages that are being set to be liquidated in the underlying case that has not been resolved yet. So how can we make a decision to issue summary judgment based on what we know the damages are against the defendant or the appellees? So for this reason, I would state that the court shall not affirm the ruling of the summary judgment and reverse the case back to the trial court for proceedings. Thank you, Your Honor.
Yes, sir. Thank you. We will hear from the appellate.
Good morning, Your Honors. May it please the court. I'm Brian Fawnin, and I represent the appellees in this case. This lawsuit is a lawsuit about a court-ordered withdrawal by attorneys made after a falling out between they and their clients. Unless Your Honor wants me to respond to certain things that the appellant has said, there's a lot in there. I disagree with nearly 100% of it, but for purposes of focusing today, where things stand now is there were consolidated cases at the trial court level. There is only one case on appeal. Only Mr. Grose, Anthony Grose, has properly filed an appeal. So all that is left of this case is the answer to the question of, does the trial court's grant of summary judgment as to this Mr. Grose's case, should it be affirmed or reversed? And I would submit to the court that there are three grounds on which the case can be affirmed. The simplest and most straightforward that will resolve this case is the fact that the appellant never came forward with 4 or 5 years of time to do so with any expert testimony to demonstrate a violation of the standard of care of any of the attorneys on the defense side. The second most straightforward way, and also the way the trial court addressed it in addition to a lack of expert proof, is the expiration of the statute of limitations with respect to the claims against these lawyers. There are several events in the record, all of which demonstrate more than 1 year prior to April 21st, 2017, when this lawsuit was filed, that you had the necessary elements for commencement of a claim for legal malpractice under Tennessee law. You had the motion to withdraw itself on March 29th, 2016. You had the filing of a notice of lien to secure expenses publicly with the court on March 29th, 2016. You have a letter from the clients to the attorney beginning to show the breakdown in the relationship in terms of what these folks wanted to pursue and what the attorneys were willing to pursue on March 17th of 2016. You have another even more strong letter from those folks on March 30th of 2016, and even a receipt in the record showing that a complete copy of the client's file had been turned over by the lawyers to their soon-to-be former clients on April 5th before the motion to withdraw was actually granted by order. Those grounds which are in the trial court's opinion are straightforward and I believe would be simple for this court to affirm, and they would resolve this case for the parties. There is a third ground that candidly, Your Honors, if you're willing to establish some precedent, I think might be most helpful to lawyers in Tennessee. And that is to adopt some version of precedent from some other jurisdictions that have had to tackle a situation like this, where an attorney is granted leave by a court to withdraw from a representation. And that ruling is either never appealed or never reversed into the underlying matter. And then subsequently, a collateral attack on that is made in the form of arguing some sort of attorney abandonment claim as malpractice. And I think a ground for affirming this decision that would be helpful precedent in Tennessee is to make clear that this sort of collateral attack on a trial court's order granting withdrawal is inappropriate. I think it's the Schibel court from the Northwest, 399 Pacific 3rd, that sort of has said it best, right? Which is, if we're going to have rules that permit attorney withdrawal, and those rules require the attorney to file something with the trial court and give the trial court authority to say, no, you have to continue to represent these people, or yes, you're allowed to withdraw. We have to allow attorneys to have confidence in those rules. And so whether you pick from the cases that sort of talk about variations of collateral estoppel issues, variations of law of the case issues, concepts of judicial immunity, or just simply a breaking of the chain of proximate causation, that if a litigant is trying to claim that they've been abandoned by an attorney who in fact followed all the procedures with the court to be granted withdrawal, it would be helpful to have some precedent that says that's not a viable cause of action, because after all, attorney abandonment is really about those lawyers, and we have them from time to time in this state, unfortunately, who, for whatever their reasons are, just sort of walk away from their practice and do in fact leave clients in the lurch. And we want to encourage attorneys, obviously, to never do that. And one of the ways to never do that is to seek leave to withdraw from the formal and appropriate procedures. And in this case, there is no question that the trial court in the underlying wrongful death matter granted all of the attorneys that were representing the Groses leave to withdraw. That was never appealed and instead has been subject to this collateral attack. But if the court wants to just keep it on what resolves the issue for this one remaining litigant's appeal, there are very simple grounds on established Tennessee precedent about requiring expert proof of a violation of the standard of care that have not been met here. The appellant talks about the fact that there was no discovery done and no scheduling conference, and all of that is correct, but the pro se appellant doesn't and sort of hasn't grasped that as the plaintiff in the case, the responsibility for pursuing those things falls on his shoulders. It was not the trial court's job to somehow tell parties to pursue discovery. It was not the trial court's job to establish a scheduling order. No motions were ever filed to seek them. No efforts were ever made to take depositions, and there were no prohibitions imposed. So there have been, depending on whether you want to count it as just time from when this case was remanded after the initial grant of the motion to dismiss, you're talking another 2 years have passed without any effort by this litigant to pursue discovery. Or if you want to go all the way back to the original filing of the case, 4 or 5 years without ever pursuing that. They were never obstructed from doing it. They had every opportunity to do it. It was not pursued. That may have been through a lack of understanding, but as this court knows, the rules for pro se litigants, while they are lenient, they do not allow them to simply have no understanding of how the rules of procedure work and be able to excuse the failure to pursue discovery by not understanding our rules of procedure. And then, of course, there's ample evidence in the record to show that by April 21st, 2017, actually by April 20th, most realistically by probably no later than April 1st or 2nd of 2017, but probably a few days earlier than that, the 1 year period for complaining about the very things that were memorialized in these letters and involved the breakdown of the attorney-client relationship that led to seeking withdrawal. All of those things had happened. They had caused some injury, even if only slight, and the awareness component was definitely met because these things that happened out in the open and in the exchange of correspondence among the various parties.
So when do you say the statute of limitations began to run?
I would say, Your Honor, that at the very latest, it began to run on April 1st, 2016. That is the date of a letter from David Kustoff to these plaintiffs responding to their letters and further clarifying what they already knew from telephone calls, which was why the Kustoffs were not interested in pursuing the kind of litigation that these folks wanted to pursue. Because by that time, in addition to that letter, you also had a publicly filed motion to withdraw, and you had a publicly filed notice of lien in the record. I think, Your Honor, it could be that the statute ran as early as the March 17th letter that was actually what prompted the Kustoffs to decide this is not a case that's going in the direction where we're going to be rowing in the same fashion. That was sort of the letter that let them know this family wanted to pursue claims involving conspiracy theories against the police and the fire department rather than wrongful death lawsuits over the automobile accident, and is what prompted the Kustoffs to make the decision that they needed to get out of this case and let the Groses pursue it however they wanted to pursue it.
Why would the date that the motion was actually heard and granted not be the date that we're looking at?
Because under Tennessee case law about what is necessary, it's a variation on the you cannot wait to see how complete the damage is before filing the suit. And so here, if the court compares what's in the various correspondence in terms of what's being complained about in the handling of this case to those communications, they're complaints about the same factors. And under the even a slight injury accomplishes it, the public filing in this case of a motion to withdraw and an attorney's lien is a not insubstantial injury, because it certainly at that point, if you were defending the case, you now know, there is a breach of the attorney-client relationship, essentially, that this attorney and this client are not getting along, and this is heading down another path. If you speculated out a case where, for whatever reason, they then reconciled and pursued, I think you still have the running of that clock on those damages. And that would be true if really the only thing that was being asked for here was, hey, you're abandoning us. But the abandoning us argument comes along with, we don't like how you're handling the case. We don't like that you won't pursue certain claims we want you to pursue. And all of those, the record reflects, Mr. Grose and his family knew about that fact, and they thought that fact was wrongful even before the motion to withdraw itself had been granted. You can read some of those letters, and those letters are at least subject to some reading, particularly the March 30th letter. They don't read that dissimilar to a, I don't want you to be my lawyer anymore, I'm firing you letter. They don't quite go that far, but they're pretty far down that path.
Two thoughts on that. First of all, doesn't that type of analysis from a summary judgment perspective require a particularized factual finding? And I'll ask the second question too. You can answer both of them. The trial court could have denied the motion or the request to be allowed to withdraw here. So why would that not be the objective date that we would look at, especially in light of the fact that there, as best I can tell, there's no particularized finding about what those letters meant and the harm or the damage that it caused to the attorney-client relationship?
Your Honor, my answer to that would be sort of twofold. Is I think it's because of how Tennessee establishes when the commencement runs, and in sort of the same fashion to when a potential mistake is made in the handling of a case. Our case law does not say that that claim only starts to run if there is a final ruling confirming that that error has been made versus the damage occurring. And then my second response to that would be, so it's the larger issues on the statute of limitations. It's I think that sort of ruling would be inconsistent with Tennessee's guidance that we aren't really a wait and see sort of jurisdiction. And the notion of a client having to show up in court and argue to a trial judge against their own attorney being allowed to withdraw from their representation, I think that satisfies the slight injury test. But my second response would be, I think that's why, Your Honor, when I phrased the argument at the beginning, the statute of limitations is a straightforward way to affirm the trial court's ruling, but I think it is the second most simple way to do so. I think the simpler path is the lack of any expert testimony about the standard of care. So if the court did not want to wade into exactly when the statute of limitations ran, I think the appeal can be the ruling can be affirmed simply on the grounds of that it's undisputed that there's no sufficient expert testimony in the record to support the claim.
Thank you.
Were there any other questions, Your Honor?
None from me.
Well, I do just want to say we very strongly ask that whichever parts of column A, column B, and column C you might be willing to pursue, that this court affirm the trial court's ruling granting summary judgment. And on a personal note, I do very much appreciate you allowing this argument to go forward by Zoom. It's very much appreciated given the state of affairs going on these days. Thank you.
Thank you. All right, Mr. Grose, I believe you have some rebuttal time.
Thank you, Your Honor. I would state to say that the statute of limitation in this case is centered around the order that was issued by the court of April the 21st, the date that the court issued the order to allow the defendants to withdraw. And when that case came, when that withdrawal order came, it went before two judges, and one judge, the initial judge was Donna Fields, and the other judge, it went before another judge because the other judge was out. Donna Fields was not present for the date, so another judge took the case to hear it on the order of the withdrawal. And that judge would not hear the case and explain to the defendant, David Kustoff, that he had to come forward with a reason for the withdrawal, which he failed to do, and that's in the record. So the case was sent back to the original judge in Division 7, I believe, Donna Fields. And when it still came before the judge on order, in accordance with the local rule, there was no reason given at that time why the withdrawal was being withdrawn. So that left the plaintiff standing still for litigation to continue the pursuit of an inheritance and they're being beneficiaries to a wrongful death claim. So, and it was stated that and told that the defendants would have to find an attorney. And after the notoriety of the defendants, no local attorney would intervene on behalf of the plaintiffs to assist in pursuing the wrongful death claim. So the statute of limitations centers around the breaking of the local rule where the attorney did not give a substantiated reason for the withdrawal. If that was to be said, that for the letters that came in, the plaintiffs were instructed to present letters for relief to handle the theories basically came from the attorneys, that this case had to have an expert for the wrongful death case, and that there was mishandling by the police department and the fire department in the wrongful death case. So the theory and the release, the plaintiffs were told and instructed to present a letter for request for release just to handle a particular part of the pursuit of, if there wanted to be damages and claims being charged against the Memphis Police Department and Memphis Fire Department in the handling of the on scene case and the investigation. So it's evident. If we go down the rule, like he's saying, for us, the statute of limitation, the statute of limitation is set by the order of that the court issued, which broke the contract between the attorney and the client. For as the standard of care is unique in this case because the plaintiffs have sought numerous attorneys, as we stated, and the attorneys have outright explained that they would not intervene in this particular case against another professional of the notoriety of the individuals that are listed in this case. So we would ask that the court look at the case because it's unique, look at this case real close and see, with there still being an ongoing litigation into a wrongful death case, there are still damages to be sought. And the damages that to be sought in that case, based on what the damages are being for the attorney, for what we're talking about, it's up in the dollars, but still, we don't know what damages can come from that case and how can there be a ruling on this case if the other case, the underlying case has not been resolved. You have any questions, Sharon?
I don't see any, Mr. Grose.
Say again?
I don't see any questions.
Well, I would ask that the court would take a look at it. It's a unique case. And thank you for your time and listening to us today. Being that everything's going on with COVID-19, we appreciate you taking the time to listen. But what's in their briefs, the appellate briefs, as well as the reply briefs, is pretty much covered. Thank you.
Thank you, sir. Thank you. Thank both of you for your argument. We appreciate you participating via Zoom. Now, Mr. Grose, what we're going to do, this is different than the trial court, is we will take this matter under advisement and we will review the record and write an opinion. And when we get the opinion finalized, we'll mail that or email it, however that needs to be done, to both of you at the same time. So there won't be a decision made today. Okay?
Thank you.
All right. Thank you, sir.
Thank you, Your Honor.
Thank you. Ms. Tibner, anything we need to take up?
No.
All right. Let's recess court to the call of the docket this afternoon.
This court is now in recess until 1 p.m.
All right. Thank you all very much.
Thank you.